Complaints based on Title VIII should be filed with the Office of Equal Opportunity, National Civil Rights Commission, your local board, or the National Association of Realtors. Complaints based on Title VIII. All right. So the right answer was Office of Equal Opportunity. So National Association of Realtors. So, you know, your Title VIII is based on discrimination. So it's equal opportunity. And National Association of Realtors is more about ethics complaints or violations that way, or realtor to realtor complaints. It's not necessarily a complaint based on any types of discrimination or anything like that. That should be sent to the Office of Equal Opportunity. All right, who jumped out ahead? Okay. What protected group is covered under the Ohio Civil Rights Law, but not under the Federal Civil Rights Law of '68? Handicap, sex, ancestry, or national origin? All right. So one of you got ancestry, right? All right. So national origin was the other. National origin is protected. Ancestry is the only one that is not. So that's ancestry is not part of the federal civil rights. It is under the Ohio civil rights. So you know, that national origin is actually under you know, under the federal. So. Oh, Jim coming in. Nice. Which of these is not a way an Ohio agency relationship can legally be terminated? The broker dies, the client files for bankruptcy, the buyer client dies, or the salesperson dies? There you go. You guys are figuring it out. Once you see the answer, you can answer it and still get points. All right. So yes, you know, your agency agreements are between your broker and the client. So if the salesperson dies, it doesn't matter. You know, well, it does. You know, they died, and they're not part of the agreement. So in the eyes of the contract, the salesperson is not part of the agreement, and their death does not terminate that agreement. There we go. Now we're getting some people on the board. All right. What would enhance the value of real property? A picture of a Mona Lisa hanging in the hallway, a toxic waste dump being built next door, an above ground pool, or a 2-car garage? All right, who's guessing toxic waste dump? Who's going toxic waste? All right, so an above ground pool. An above ground pool is actually not, it's not part of the property because it's above ground. If it was an in-ground pool, it would enhance the value of real property, but because it's above ground, it is not actually considered real property. So only a 2-car garage would. Everything else would not matter. All right, we got somebody else coming in. So let's see where we are. Ooh, Kev on the come up. Nice. All right. Property is attached in order to compute cost replacement value, transfer title to the mortgagee, construct zoning boundary lines, or provide security for payment of a debt or judgment. Right. Provide security for payment, debt, or judgment. So when we talk about attaching property, that's usually in court. So when you're attaching a property, you're attaching it to a court. You know, when that's based on like lawsuits or anything like that. So you attach the property to the suit in order for it to secure the debt or the judgment against whoever it is. So just remember, if you're attaching property, it's a court thing, not construction or transfer title. It's due to court. Ooh, 3 players with the answer streak. An out-of-state prospect asks an agent to locate a diverse neighborhood for him. The agent should not take the prospect, show the prospect the diverse neighborhood, state that research of this nature is beyond the agent's scope of authority, or research the population trends in the neighborhood. So what should an agent do? All right, you got a split there. Research and number 3. So in these cases, it could be considered steering or discrimination if you were to actually tell them about the neighborhood or research the population trends. Because if they're looking for a diverse neighborhood, you can send them to websites where they can do that research on their own. Just like if someone asks, I want to be in an area with the best schools. You can't talk about that legally as a real estate agent. You would send them somewhere where they can find the information. You can help them get to those websites and give them to them. You cannot provide that information, or you would be steering, which is illegal. All right. A broker who deposits clients' money in the same bank account as the brokerage operating funds is guilty of conversion, merger, commingling, or binding. All right. So commingling, yes. Commingling is when you mix funds. So think of mingling like when you're going out and at a mixer. So if you mix your brokerage funds or earnest money or property management money, deposits or anything like that with your funds, it is considered commingling, and that is illegal. So commingling is, think of it as mixing. So if you mix the funds, then that is illegal, and that's what is happening here. Ooh, TWM on fire. So Tiana killing it. All right. If Ed purchases a property from Susan by an installment land contract, when will title pass to Ed? When the deed is placed in escrow, when the contract has been signed by all parties, or when the deed is delivered to the buyer, or when the seller exercises the liquidated damages clause. All right. So yeah, when the deed is delivered. So contract signed, it's an installment land contract, so that means that he's paying in installments. So he wouldn't get the deed right away. He would get the deed after the installments have been paid. So when the contract is signed by all parties, that's right when it happens, and it's not when the contract closes either. So just when you have an offer and everyone signs, it becomes a contract. That does not close the contract. The contract would determine what things have to fall into place for it to close. So it's the close of the contract that deed usually transfers. And so when the deed is delivered to the buyer would be the correct answer on this one. We got somebody in the waiting room. Yeah, you're good. You're good, Desiree. All right. Next. All right, Jim on the rise. Number 9, a listing agreement is an agreement between seller and buyer, salesperson and broker, seller and salesperson, seller and broker. This should be an easy one. We already answered this pretty much. There you go. All right, so there was a little confusion. So the listing agreement is a seller's agreement. Buyer agency agreement would be a buyer and the broker. A listing agreement is between the seller and the broker. Remember, when you have an agency agreement, it is between the broker and the client. The salesperson is actually not part of that agreement. They are an instrument of the broker, but they are not the actual one who is in the agreement. So when you have, it's not salesperson and broker, because that would be an agreement between, there would be no listing in that situation. Seller and salesperson, again, salesperson is not part of the contract, only seller and broker. So remember, whenever they're talking, they'll ask you that in different ways. So whenever they're talking about a listing agreement or a buyer agency agreement, the person who dies, it would have to be the broker or the seller. The salesperson is not involved. Just always remember that. In an agreement, the salesperson is not part of the agreement. The basic requirements for an offer include neither objective intent nor subjective intent to contract, objective intent, both objective intent and subjective intent to contract, or subjective intent to contract. That's actually hard to say quickly. All right. So yes, objective intent. So that's the basic requirement of an offer. It's the intent to purchase the property. It's subjective intent. So not subjective or any of the other types of intent. It is only objective intent. They have an objective intent to offer on the property. So that's the only requirements. And if there are questions, anything, in most states, the listing broker has a fiduciary duty to the salesperson, buyer, customer, or client. The listing broker, who's the duty to? Fiduciary duty. There you go. Good job. The client. All right, some movement there. Mo on the rise. All right. To be an effective property manager, a licensee must be familiar with a variety of agency disclosures, independent contractor agreements, employment contracts, or lease agreements. They're going to make you wait for it this time. Yes, lease agreements. Property managers must be familiar with lease agreements. Oh, it keeps kicking you out. Hold on, Kailisha. The code is actually, if you can see it at the bottom of the screen, it's 2567038. So it's right here at the bottom. So I'm not sure how much of the screen you can see, but 2567038. There you go. All right. Okay. All right, Tiana killing it. Got the lead. If the title to property is held for the benefit of a beneficiary, the legal arrangement is called a trust, a corporation, limited partnership, or general partnership. Now remember, benefit and beneficiary. Property held for a beneficiary. What's it called? Right, a trust. So a trust, and honestly, for all of you getting into this business, definitely look into trust, because it can help you tax-wise. So talk with your CPA and your financial advisors about what trust can do for you. All right. Effective gross income best describes gross income in an ideal situation with no vacancy and collection losses, gross income minus debt service, gross income minus a figure for vacancy and collection losses, or net income. So what is effective gross income? All right. Yes. So it's minus vacancy and losses. Once you take out debt service and everything else, then you're talking net income. So, so your gross income, think gross is the bigger number. Net is once you take out the debt. So once you take out the expenses and everything else, that's your net. So gross is big, net is what you actually get, what you pull into the net. So think of it that way. When the principal terminates the agency relationship before it expires, it is called renunciation, revocation, repudiation, or rescission. All right, so some questions on that one. So it looks like some of the stuff is around vocabulary. So revocation, think to revoke. So if the principal terminates the agency before it expires, think of it as they're revoking that agency agreement, the agency relationship. You know, repudiation, you know, that's to repudiate. It's not part of it. And rescission is if you take it back. Like you know, in lending you have a 3-day right of rescission where you can't get my name back. Yeah, so you have a rescission is where you like take it back, but revocation is where you terminate it previously, so you revoke the right to it. All right. A lump sum payment of principal is due at the end of which type of promissory note? A balloon, a major, a fully amortized, or wraparound? Where's a lump sum due? All right, everybody got that except one. And fully amortized. So when your amortization is when it actually works the debt all the way down to zero. So if it's fully amortized, then that means there's actually no money due. So the balloon is when there's a lump sum due. You have a payments, and then all of a sudden, think of it, you're making payments, and then it balloons out into this big lump sum. Amortization means that you've paid down principal and interest all the way to zero. So if it's fully amortized, it's down to zero. Gem on the rise. Who determines whether an Ohio complaint should proceed to a formal hearing? Is it the administrative law judge, real estate commission, a hearing examiner, or the superintendent of real estate? Not going to give you any help on this one. All right, good. Most of you got it. Yep, the superintendent of real estate. They're the ones who decide if it should proceed to a formal hearing. Net income best describes potential gross income, income before expenses, income after expenses, or effective gross income. So we just went over this, so you guys should all get this one. Okay, so again, net is your income that you actually receive. So, you know, think about if you're fishing, like the gross income would be all the fish that are in the water, and the net income would be what you actually pull into the net and bring into the boat. So it's your income after expenses, not before, because income before expenses is your gross income. Kind of like gross pay versus net pay. Your gross pay is your pay before taxes, and your net pay is what you receive after taxes. If you've had salary jobs where that's how you looked at it. All right. Which of the following is an example of commingling? Mixing earnest money with personal funds, paying licensee bonuses from forfeited escrow deposits, mixing two earnest money deposits, or using escrow funds to pay business expenses. All right, let's see how many. Oh, yeah, we had some good listeners. Mixing earnest money with personal funds. All right, and I can see why you would think using escrow funds to pay business expenses, but that isn't actually commingling. That is different because it's not saying that you mix them. It's just saying that you used it to pay business expenses, which is still illegal, and at the same time, not the same as commingling. So remember, when they use the words, make sure it matches, even though this is illegal and shouldn't be done, it doesn't mean that it is commingling. So remember, commingling is mixing. So not paying something, but mixing the two. The rate of commission that may be charged on the sale of improved property is a rate agreed upon between the broker and the property owner, 0.06, the rate agreed upon between the buyer and the sales associate, or the rate agreed upon between the broker and the sales associate. And 0.06 is 6%. So by the hesitance, I can see that there were some questions around that. So remember, it's between the broker sets the firm's fee, and then it's between the broker and the property owner. The agent, may be out there. So whoever answered the rate agreed upon between the broker and the sales associate, those two, remember, the sales associate is never involved in the actual contract other than being an instrument of the broker. So, the sales associate may be the one there, and they may be the one, negotiating on behalf of the broker, but they are negotiating on behalf of the broker. So it is between the broker and the property owner. Fewer buyers in a higher price range would create what kind of pressure on housing prices? So fewer buyers in a higher price range, would it be downward? Would it be strong, steady, or upward? Fewer buyers in a higher price range, what kind of pressure would it create on housing prices? Think supply and demand. There you go, downward, yeah. So we're in a different situation right now, okay? So we're in a situation where there are a lot of buyers in the price range and not enough homes. So we would have the opposite effect. It's creating upward pressure on prices because, if any of you have tried to buy a house recently or seen the news, I'm sure you know. The leasehold estate that can be terminated by either party and cannot be assigned is, so this is a leasehold estate, tenancy at will, joint tenancy, periodic tenancy, or estate for years. So what cannot be assigned and can be terminated by either party? They kind of gave it to you right away. They opened it up too quickly. Yeah. So tenancy at will. So if it's at will, either party can terminate it. And then, it can't be assigned because it's at will and, you know, you can't assign that. So I don't know how to explain it better. It just is. A broker offers a seller a free trip to Hawaii in return for a property listing. What is true? The buyer and seller must agree to this inducement. The broker must disclose this in real estate sales contract. The broker must disclose this to any potential buyer. The broker must disclose this on the listing contract. So where do they have to say it? Offering a free trip for the property listing. All right. Yes. So it has to be disclosed on the listing contract. And I would understand, you know, the buyer and seller must agree to this inducement. Generally, everything has to be disclosed to everybody. Now, the listing contract, it's an inducement for the property listing. So it's an inducement for the seller. So it would have to be disclosed on the listing contract saying that that's what they did to get the listing. And agreed upon and signed. In a suit brought under the Federal Fair Housing Law as amended, punitive damage may be as much as $10,000, $1,000, $50,000, or there is no limit on the punitive damages. What do you think? We limited? Ding, ding, ding. There is no limit on punitive damages. So there's a limit on, you know, just like it says, you've got an individual may be fined for that for a violation and $55,000 for a third. But when it comes to punitive damages, there is no limit. So be careful. The offeror is the person who performs as agreed, accepts the offer, makes the offer, or breaches contract. So who is the offeror? Is the person who makes the offer, right? So the offeree is the person who accepts the offer. All right. Which approach to value is typically used for investment property of 2 to 4 family units? Cost approach, revenue approach, income approach, or sales comparison approach? Now remember, this is valuation. Which approach to value? So think CMAs. All right. So some people had cost approach, so income approach. So cost approach, a lot of times what, you know, sales comparison and cost approach is mainly like commercial. So when you're looking at cost approach, a lot of times you're looking at commercial or new builds, that kind of thing. Income approach is when you're looking at investments. So think about, you know, an investor is going to look at how much does that property generate? So how much income is coming off of it? That's what they care about. So when you're talking about, and when you see investment, typically you're going to be looking at an income approach, and especially on 2 to 4 family units. You know, valuation, because you're going to look at, yes, you're going to look at the property value, and you're also going to then look at, well, how much is it bringing in? What kind of cash flow is it? What's the cap rate? Things like that. So working with investors, you're typically going to be looking at income. The buyers had no idea there were different ways to take ownership. They need your help. You should. Usually married couples want survivorship so they can avoid probate court. You should advise them to ask their attorney, advise them to ask their family how they took title, or give all the details you know about the different co-ownership. Good job. Well, I know it kind of opened it up. Yes, advising them is practicing law. And I know you want to do it, you want to talk to them, you actually can't. You got to ask them to advise them to ask their attorney on which way is best for them. Yeah, everyone wants to do the green one, give all the details about co-ownership. But again, unauthorized practice of law. From where does the real estate licensee get the 19 articles of the Canons of Ethics? The National Association of Realtors, the Ohio Association of Realtors, the Ohio Real Estate Commission, or the Division of Real Estate? So remember, Canons of Ethics versus the Code of Ethics. They can trip you up. Yep, I thought it might. Right. So, it's the Ohio Real Estate Commission does the Canons of Ethics. So if you've ever got these questions, and they'll probably ask you a few different versions of this, the Canons of Ethics is the only one that has a legal stipulation where, you can like lose your license, you can, that's the legal side. That's the Ohio Real Estate Commission. So the Code of Ethics is the National Association of Realtors. You can have some things happen to you, some violations, but the National Association of Realtors isn't the legal side. The Ohio, so if you see Canons of Ethics, think legal. If you see Code of Ethics, think, your local board, your National Association of Realtors. What special concern do foreclosed properties often present? Buying the property at a discount may have tax implications. The property sale may be subject to additional fees to be passed to the new buyer. The homeowners may or may not have property insurance, or there could be hidden issues. So foreclosed properties, what do you think the issue? What do you think the things are? Yep, there could be hidden title issues. Because you don't know what happened to the property before, and you're not getting it on a general warranty deed. So there could be issues with title once you move forward. So always be careful of that with your clients. An option agreement is neither a bilateral contract nor a unilateral contract, a unilateral contract, a bilateral contract, or both a bilateral contract and a unilateral contract. Yes, it is a unilateral contract. So when you have an option, only one person is obligated to perform on that contract. So, because you're basically saying, hey, Mr. or Mrs. Seller, if you sell this property, can I have an option, first option to buy? And so that's, you're saying only one person is obligated in that agreement, because the buyer could back out at any point. They don't have to. But the seller is obligated to give them the option if they sell. So that's what that agreement, it's unilateral because only one person is actually bound to the agreement. The other person can back out at any point or not perform, is a better way to put it. The principal broker has the following duties except oversee and direct operations, comply with fair housing documentation requirements, comply with office requirements, or prepare listing agreements. Yes, prepare a listing agreement. So I saw a couple of you saw comply with office compliance in the rationale. But it's, the principal broker, that's not they don't prepare the listing agreements. That's for the agents in the office. So that's not their duty. Everything else is their duty. So when it said compliance, that's actually part of their duty. So remember, the way they ask these questions in the exam is you'll see this a lot, except or not, or any of those kinds of things that'll say, oh yeah, the principal broker does these things. That's what they do. Well, they said accept. So just read the questions carefully, because they do word things in a way to trip you up. Because remember, your job as real estate agents are to be negotiate offers and contracts. So you have to be able to read them with understanding and not get, mixed up on what it is that you're conveying to your client. Who is not an agent or a sub-agent? A salesperson employed by a broker who has listed an owner's home for sale, a non-licensed personal assistant of an agent, a property manager managing property for others. Yep. Property managers have to be licensed. So they would be an agent or sub-agent. Non-licensed personal assistant would not be an agent or sub-agent. Oh, Kevin on the rise. Harvey enters into a lease where he must pay 30% of the landlord's expenses. Which type of lease did Harvey sign? Was it a gross lease, a percentage lease, or a net lease, or a land lease? He has to pay 30% of the landlord's expenses. Which type of lease is it? That gets people all the time. So because they say it's a percent of the landlord's expenses, people think it's a percentage lease. But a percentage lease, that's a net lease. A net lease is when you pay a portion or all of the landlord's expenses. A percentage lease, did they explain it in here? Yeah, is when you pay a percentage of the profit. So that's what a percentage lease is. So say you have a business, once you do a certain amount over a certain profit, you pay a percentage of that profit to the landlord. And that's what a percentage lease is. Whereas a net lease, you would actually pay some or all of the landlord's expenses. So be careful again with the wording, because they said 30%, percentage lease sounds right. It is not. In a real estate transaction in which you represent the seller, your duty to the other party is to be honest in all matters that do not affect your client's interests, be polite and courteous, maintain the confidentiality of all matters that others disclose to you, or treat them honestly and fairly. Honesty and fairness. So that's your duty to all people. Honesty and fairness is your duty to everyone. So, what do we have? Maintain the confidentialities. Yeah, but again, that's to your client, not to other people. So if you have a client, yes, you have to maintain the confidentiality of your client forever, unless subpoenaed and required to break that confidentiality in court. That is the only time you're allowed to break confidentiality of your client, is if subpoenaed. As far as anyone else, if you hear information, your job is to give that information to your client, because you don't have a duty to confidentiality to somebody who hasn't signed with you. So just honesty and fairness, that's your duty to everyone. Which word or clause in a mortgage pledges real property as collateral for the debt? Hypothecation, accretion, acceleration, or acknowledgement? Yep, hypothecation. So acceleration is when a lender accelerates the due on clause. So they're basically accelerating the loan. They're saying it's due now. So that's acceleration. Accretion is actually like, I think it's when like soil degrades over time, like on like a riverfront or a lake. So that's accretion. Or is it when it? No, it's the gradual buildup. Accretion is build up, and then acknowledgement is just acknowledging like a witness to the signature. So hypothecation. That's when a real property is pledged as collateral for a debt. Harvey enters into a lease where he must pay 30% of the landlord's expenses. Which type of lease did Harvey sign? We just did this one. So everyone should get it right. You should all get a freebie right here. Quick answer freebies. There we go. All right. Good job. The purpose of the Ohio Real Estate Canons of Ethics is to bring professional standing to the practice of real estate, eliminate part-time sales agents, make it harder to get a real estate license, or produce revenue for the state of Ohio. All right. I like that one. Make it harder to get a real estate license. That's a brief summary of a property's history listing all recorded documents that may affect the title is a certificate of title, title insurance, title report, or abstract of title. Brief summary of the property's history. All documents that can affect the title. All right. So title reports list all the defects. So a title report is going to list all the issues. The abstract of title is a summary. So if you're thinking a summary, think of the abstract, just the abstract of it. I don't know how to explain it in a better way, I think. And then certificate of title, that's actually the, it's an attorney's opinion. So of titles. So that's the certificate of title. An attorney's opinion. The title report is the defects that go along with the property. And then abstract of title is the summary of the history. Kind of like in research papers, the abstract is the summary. So I don't really know a better way. The taking of another person's rights and obligations in a pre-existing contract is known as assignment, ostensible liability, assumption, or novation. All right, everybody got that? It is assumption. Hope's mortgage created a lien against the property she purchased with the mortgage. What kind of lien is this? A general lien, a vendor's lien, a special assessment, or voluntary? Now, Hope got the mortgage, so what kind of lien? Right, voluntary. What is the best description of a deed? A covenant, an abstract of title, a document to transfer ownership, interest in real estate, or a recording fee? All right. Refusing to make loans based on the racial composition of a neighborhood is called blockbusting, exclusionary zoning, steering, or redlining. All right. Everybody got that one. It was visible though. So hopefully everybody actually knows that one. Because remember, when it comes to loans, loans are redlining. Steering is shifting people to certain demographics, like we talked about if they ask about diversity of a neighborhood. Blockbusting is when they come in and try to get people to sell by saying that, by creating fear. And so they get people to sell and bust the block and get people to move out so they can sell the properties. And zoning has to do with, the courts and legal zoning, the city. A disabled tenant was denied permission to install a handlebar in the shower. What law has the landlord violated? The Fair Housing Act, the ADA, no law has been violated, or Civil Rights Act of 1866? Yes, ADA. So when you're talking about disabled, it's Americans with Disabilities Act. So that's what they violated. Fair housing isn't what's violated. So think of fair housing as the whole house, the outside. So if they said no, you can't buy this house, that's one thing. If they say no, you can't put a ramp on it, that's ADA. So fair housing is just a matter of the buying and selling of the property versus ADA, which is about, the actual interior and use of the property. So one's kind of macro, one's micro. What is not an example of real property? A sump pump, a shed, drapes, or a bathtub? There you go, drapes. So a sump pump, so when you think of real property, think of anything that's affixed to the home that would make it seem like it is part of the home. So if you've got a sump pump, there's probably a hole there, and the pump is inside the hole and it's attached in a way that would make it seem part of the home. Same thing with the shed or a bathtub. It's not something you can just pick up and walk away with. So, anything that's affixed in the way that would make it seem permanent to the house or a part of the house. Jules is new to property management. Which of the following tasks may be one of her duties? Creating a budget for the next year's projected maintenance costs, purchasing the apartments to be managed, investing profits from the business, or representing the owner in court. So if you're a property manager, what do you think your following which one would be part of your duties? Yes, creating a budget for the next year. So investing profits from the business, that's for the owner to do. So you don't want to mess with other people's money. So if you're a property manager, that's for their financial advisor or the owner to do themselves, not for you as a property manager. And then representing the owner in court, that's actually typically extra. You pay extra for that. So yes, they can do that, and at the same time, it's typically gonna kind of cost you more. But the general duties of a property manager are to be doing this. While both the mortgage deed and the mortgage note are signed by the borrower, the note is assigned in duplicate with a copy each for the buyer and the bank, not really necessary, not recorded, or retained by the borrower as a reminder of its maturity date. All right. Yes, it is not recorded. Signed in duplicate. So you saw if it was signed in duplicate, that would create two liens. And then retained by the borrower's reminder of maturity date. I could see that one being, but it's just not recorded, and it's actually retained by the bank, not the borrower. So the note is basically the borrower's promise. So it's held by the bank. A broker lists a home which cannot terminate this agreement. Everyone should get this. Death of a broker, death of a seller, seller bankruptcy, or death of a salesperson, which cannot terminate the agreement. Who's not part of the deal? All right. So again, a broker can terminate the agreement if the broker dies. And if the seller dies, it will terminate the agreement. So remember these words. When they put in these words, you got to pay attention, because it's only a salesperson that can that would have no termination on that. Broker and the seller are in the agreement. Either one of them dies, it terminates. The salesperson will have a buyer sign an Ohio State agency disclosure form at the closing, prior to qualifying the buyer, prior to writing an offer, or prior to showing the properties. An Ohio State agency disclosure form. Yeah, prior to writing an offer. So again, that's different than your what do they call it? I'm blanking on the word right now, but it's not the disclosure form. The agency disclosure form is just for writing the offer. You know, agency. Man, can't think of the name. It's not consent. It's like a consumer guide to agency. So that's what you give them prior to showing properties at first contact, is consumer guide to agency, not the agency disclosure form. So you know, it's your consumer guide that you're giving. So that's what you give when you first meet. All right, so we made it almost halfway through, and it looks like Tiana held the lead. Jim was coming up, and then Nicole and Mo, and then Kevin. So good job. And you know, it's 7:01 now. I'm gonna send you all, everyone who is in here. I'm gonna put some links in here real quick. So you'll probably want to take these links down. Give me just a second. And so anybody who's still in here, here are some links that you can go to. So you'll want to take these down, because these are YouTube videos, and it's basically the 2020 Ohio State exam, real estate exam, the 2021 Ohio State real estate exam. They go over all the questions, and then there's a couple videos on how to do the math, and then there's one on the national portion of the exam. So they basically are videos that go through, and you know, they'll do like 50 to 100 of the questions that are on the exams. And so these are the actual past exams. So, you know, it gives you an opportunity to look at the way they ask the questions. In the videos, they'll actually go in and kind of discuss each part and why the questions are. So definitely, you know, grab these if you can. Yeah, so it's, you know, these are going to be good study guides along with everything else you've got going on. And beyond that, that's our time for the evening. You know, if there are any questions, feel free to reach out. I'm here to help support you in your goals to become real estate agents.